Hi everyone, welcome to this episode of the Immigration Lawyers Podcast. I'm so excited to bring another episode, which is different from the last two, not a weekly, but something I try to do in the middle of the weeks, which is discuss in detail areas of law and analyze cases. This one's going to be about the EB-1C multinational manager or executive green card, and I'm going to analyze 4 different AAO cases and talk about interesting points of law and analysis that were brought up that are kind of different than the typical AAO case that comes out. Note that I'm going to go very deep in the rules and it's going to be very technical. So it's really for business-based practitioners or those interested in this area. Frankly, it might get boring if you're not into this stuff. But if you are, you're trying to learn the area, there's some nuanced stuff that can be very fun and interesting if you enjoy thinking about this stuff like I do. Without further ado, let's get started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi, so I'm going to be talking about 4 different cases, AAO cases that recently came out and the decision the AAO did. And there's 4 cases. Of those 4, 3 of them are great examples of bad counseling, if you will. I'm not sure if attorneys did this or not. And I'm sorry if you're hearing this and you were a part of this case, but the decision making to even file these cases, let alone the courage, if you will, to even file an appeal on these cases is tremendous when you could just read the rules and it's obvious. One of them to me was really obvious, but the AAO said it's a nuanced issue that they wanted the director, USI's director who made the decision said it's a nuanced issue that they want to take up to AAO for them to decide. But it wasn't too nuanced for me, and I don't think it should be for you. It wasn't too difficult to know that the petitioner was wrong. But let's get started with the first case. This is Matter of N Incorporated, January 13th, 2017. It's about, has 2 parts to it that come up that usually don't come up with AAO cases or EB-1C cases. But it's kind of cool to talk about because it goes into the perm-related EB-2, EB-3 categories. The first part of this case, Matter of N, is the successor in interest idea. Here, the petitioner was a producer of mobile devices and was going to petition for an immigrant visa petition for a senior manager. Now, the senior manager had come into this original petitioner to work for them, but a few weeks or a few months, and a lot of it is redacted, so there's chunks of it that are missing, but the idea comes out pretty clear. So he gets hired, is working with the U.S. petitioner. I think they were probably on L1 before. U.S. petitioner files the EB-1C petition and adjustment of status at the same time. And about, say, 2 months afterwards, the petitioner goes out of business, sells all its assets to another company, and it kind of looks like it was planned all the time to, make the other company bigger from the pieces of the old one. And the petitioner here, once the case is denied, they wanted to argue successor in interest to say the petition was kept alive because another company got all the assets, so it was just a matter of transferring, similar to an EB-2 or 3 context. However, denial and subsequently in the AAO appeal language, they cite the adjudicator's field manual and Neufeld memo, which essentially says, in I-140 in the perm process and labor certification, it's possible to have a successor in interest, but it's not possible in an EB-1 context. In these type of cases, you must file a new petition. The new company has to file a new petition and satisfy all the EB-2C requirements. There's no 2 ways around it. Now, if this person was already working L1 and they transferred that new company, they would have had to update their L1 as a new employer as well. That's another thing we're not going to go into, but that's something to note on the I-129, notifying USCIS of the change of employer. So this was the easy answer and could have denied the case right there just because there's no successor in interest. The petitioner failed, or the beneficiary should have asked petitioner, the new company, to petition for him instead of having the same file continue. They should have noticed this and avoided the time of filing and then filing an appeal, waste of time and money, just got down to business from the very beginning. If they saw they made this mistake even after they filed, just withdrew it and did it again. There was no point to drag this down this far. Now, the second part of this case, the AEO goes into detail about the portability issue. So the petitioner tries to say there's 204J portability, and that the case was pending, or at least the sale of the company happened 186 days after a petition was filed, so that portability should have happened. The director notes that for portability, you have to have a bona fide intention to employ the person upon approval. The job offer is prospective, even though they were already working here. An I-140 job offer is prospective for the green card. But in this case, the offer expired 2 months after the I-485 was filed, before the 180 days, because the actual sale and transfer of the company happened before that time. Citing the new regs in the 2009 memo, the new regs being the January 17, 2017 regs that came into place, they talked about the petition has to be approved first before DHS examines portability. And here it's EB1C, there's no pre and processing, so there's a long delay before it's approved. Citing the regulation 8 CFR section 245.25 A2 Roman numeral 2 B2, they say in part, the pending petition will be approved if it was eligible for approval at the time of filing and until the alien's adjustment of status application has been pending for 180 days. As noted in the preamble, this regulation reaffirms existing policy rather than sets forth a new policy that will not apply before January 17, 2017. The preamble also states, consistent with current policy and practice, DHS will review the pending petition to determine whether the preponderance of the evidence establishes that the petition is approvable or would have been approvable had it been adjudicated before the associate application for adjustment of status had been pending for 180 days or more. Under the above reasoning, examining the validity of the job offer after the filing date but before the passage of 180 days is consistent with current policy and practice. Now, they state that the final rule in this preamble do not directly address the issue of the retraction or termination of the job offer, but they say the preamble does indicate that, quote, DHS ... will deny a Form I-140 petition if DHS receives the written withdrawal request or a business termination occurs before the associate application for adjustment of status has been pending for 180 days. In the instant case, and again, there's a lot of redactions here, so it's kind of hard to get the timelines down, but it says in the instant case, the original job offer no longer existed 180 days after the filing of the application. The beneficiary had transferred to a new company, and then it doesn't say exactly how many months it's redacted, but it's after the petition filing date. At that time, arrangements for the sale and dissolution of the petitioning company were already underway. The beneficiary's transfer occurred for the very reason that everyone involved knew that the company would soon cease to exist as a result of its sale. So the petitioner had not established that the beneficiary had a bona fide intention to return to that work or that there was a bona fide intention to rehire her to that original company. The original job offer described the position ceased to exist long before the critical 180-day mark, even if the petitioner continued to exist on paper for a few days after the 180th day. So they go into examining the actual sale and the details and the timelines. Furthermore, they talked about the executed purchase agreement was set for the new company to buy substantially all of the devices and services in business on the weeks before the petitioner had even filed this petition. Now, on appeal, the petitioners say, there may have been protracted negotiations that could have occurred that would have extended the life of the petitioner and the existence of the business past the 180 days, so that the ultimate deal wouldn't come to fruition because of these factors. But the AEO says, quote, in point of fact, the deal did come to fruition. They say, there's always a possibility that due to unforeseen circumstances, the beneficiary would not end up working for the petitioning U.S. employer. USCIS doesn't deny petitions because a given job offer might hypothetically fall through. On the same basis, they did not find the job offer remain valid even after the impending sale had been announced and the beneficiary had been transferred, because all the parties had the intention and were involved with the sale and permanent transfer of the position so that the original petitioning company wouldn't exist anymore. This disqualifying change of circumstances occurred well before the 180 days after the petition's filing. So overall, in this case, the successor in interest issue was big there. There's no successor interest qualification for EB1Cs. And also portability wouldn't play, let's say if that successor interest somehow did exist, because the business was essentially done within the 180 days and there's no the long-term employment possible. It was already clear that this was going to shut down with no intent of future work. Now, when I was reading that, and maybe when I explained it even, it sounded kind of confusing. And because it is, I could see arguments go on the way. It's not the clearest answer, but one thing the AEO does, and I've seen, is if they find one thing they don't like, the successor in interest, they don't want to just give a one-page denial. So they add on stuff and just pile it on. And this was confusing a little bit. But I think in the end they're right. They shouldn't have filed this case. There was no point in having this kind of thing come out and appeal. Now I have show notes to the stuff that applies to these cases I'm talking about, like Adjudicator's Field Manual, the Neufeld Memo from August 6, 2009, which talks about this, and the new regulation, the 8 CFR, that was updated in January. Now the second case was kind of fun, and it's an issue that comes up actually in my L1 cases a lot. And it's with regards to an employee or the beneficiary working overseas and wanted to come to work for the petitioner in the U.S., but they had worked overseas, but maybe they weren't the easiest, it wasn't the easiest way to show that they were directly employed for the foreign company. In this case, it's Matter of A Incorporated from January 2017. A computer software and hardware developer tried to get a green card for a software engineering manager in automation. So when they filed the case, and this is September 27, 2013 when they filed the petition, and what really frustrates me again when it's bad representation if they use an attorney in this case, is that you file something in 2013, decision comes in January 2017. So that's essentially 2 years and 4 months, if I'm doing my math right, that they're waiting for a decision on an EB1C. When at the very beginning they shouldn't have filed it because it was a bad case. And here in it says a petitioner's manager of immigration. So I think they had some sort of in-house non-lawyer probably doing the immigration stuff. But they should have caught this and not wasted 2 years and probably tens of thousands of dollars on this process to lead to nowhere. This was just obvious from the beginning. There are nuances on this, and I'll talk about, which could have gone the other way if done right. But they failed to do it here, and it comes up a lot. And I'll talk about my personal experiences after I go through the law. So the petitioner stated, and this is in the AEO decision, I think they're quoting the person, that before entering the U.S., the beneficiary that was coming to work in the U.S. worked with, now quote, not for, but worked with the petitioner's wholly owned subsidiary in Ireland. Now the petitioner here says that it has a subsidiary in Ireland, and the beneficiary did work for the subsidiary in Ireland at the direction of its Irish employees. So because of that, it was essentially an employee of its Irish subsidiary and could be transferred to the U.S. The actual employer of the beneficiary overseas was unrelated, didn't have a qualifying corporate relationship in any way, and they agreed to that with the petitioner or even the foreign company. Now they cited the Darden case, which comes up a lot, and that's something you definitely need to read if you're doing these complex L1 or EB1C cases, because it comes to the matter of who controls who, and it goes both into qualifying relationships, and it primarily then goes to if someone's really an employee. And this context comes up when I first started doing L1s and stuff like that. I rarely saw this, but the more deeper I got, the more types of calls I got, especially when people call me about L1s, E1Cs. They're on the difficult side of cases, and especially when they're smaller companies. And the issue is, when is somebody actually an employee? And surprisingly, the term employee is really vague still. It doesn't have the best definitions. It's still this convoluted explanation. And here they're arguing, the beneficiary was an employee in Ireland, even though they're employed by another company. But the fact that they were in the operations of the Irish subsidiary, they could count. Now, the Darden case, it says, in determining whether a hired party is an employee under the general common law of agency, we consider the hiring party's right to, quote, control the manner and means by which the product is accomplished. So the control they have over the person, how they do their job, is the key way to show if someone's an employee. That's very, very important. And it allows you, that kind of language, it allows you to get away with a lot of stuff in the L1/EB1C context. Because, sometimes you have people that want to transfer to the U.S. that weren't technically employed, or it's vague, they're independent contractors. If you could document, and a key is documentation, and they're going to look at this with a magnifying glass. But if you could document it, and I'll talk about like a case I'm working on, how I'm going to document it, you can get away with it, but it's tough, and you got to warn the client about this. So I say among the other factors relevant to this inquiry are the skill required, the source of instrumentalities and tools, the location of the work, the duration of the relationship between the parties, whether the hiring party has the right to assign additional projects to the hired party, the extent of the hired party's discretion over when and how long to work. That's really key. In the U.S., when you talk about independent contractors suing people for not getting paid or suing the employer, they go to the idea of, did the employer that was hiring the independent contractor have a right to control the person, say come here at 9, leave at 5, all that kind of stuff, how to talk to clients, how to represent yourself, how much control they have over them. And that's an employment law issue. But again, when you think about immigration law, people think it's all deportation. Employment law has a big play when it comes into these EB1C L1 cases, because you have to show if they're a real employer or not. Moving forward, the extent of the hired party's discretion over when and how long to work. I think I read that already. The method of payment, that was a tricky one, because sometimes they say that's here, but sometimes it goes both directions. They're pretty flexible. You would think the payment to getting paid a wage would be the biggest one, but that's not when I read these cases. The hired party's role in hiring and paying assistance, whether the work is part of the regular business of the hiring party, whether the hiring party is in business, the provision of employee benefits, and the tax treatment of the hired party. That latter one is a tricky one I'm working with on a case I'll talk about. Because in my case, the client wanted to get paid intentionally as an independent contractor because it was preferential tax treatment. You see in a lot of different foreign countries, like I have a Brazilian case where in Brazil, this is just crazy in the place they are. Like the employees get taxed at like some ridiculous number, like 80% or some ridiculous number of taxation rate that they get when they're executives. So what they do over there is they get hired as independent contractors, even though they're like CFOs and top executives in the company, so they get that better tax treatment. In the U.S., they kind of do that too. When I worked at entertainment. The names on my LinkedIn. When NBC Universal, I always saw and I was an internship there, but I saw everybody had a corporation that would be hired for their acting or directing or producing or whatever. Never that. So when you have this kind of case, you have to explain to USCIS how the system works. Maybe get a letter from a tax accountant. May get like some sort of law that says, even though they're independent contractors, that's just a scheme people use. It's a lawful scheme, but it's good for tax purposes. Really explaining that. Now, the petitioner's manager for immigration and different letters that the managers of the Irish company gave, they gave letters saying that this person is an employee, this and that, but that was it. They gave these letters talking about this, but not much else. And they said, the decision said the petitioner is relying only upon its own assertions. They submitted copies of 2 reference letters that were essentially identical. They didn't provide documentation to the nature and extent of the oversight the beneficiary had. So beneficiary working for the Irish subsidiary, how did the managers control them? How did the beneficiary represent himself as being working for the company? Nothing else, just statements. And I work mostly with small companies and new office L1s. They eventually grow a little bigger and then they go E1C. And I have to document the hell out of it because I can't leave any room for these kind of things. Now I don't get these big, companies like multinational, 1,000-person companies. Their documentation is much slimmer. I guess they don't have to document as much as I do with these small companies because they're less suspicious of them. And so this person, maybe their attorney was used to doing that kind of stuff, to just write letters, like a simple letter to accommodate USCIS's adjudication. But, letters are very important. You got to be very careful how you word them in the L1, EB1C context, but you got to document the hell out of it. Any way you could show this person was actually working there, working in the manager role. And some of these cases had issues with the manager role too, and this one did as well, which I'm not going to go into too much. But you got to do whatever you can to show this person was actually working there in any way possible. You can't leave it up to chance or have some 2 letters. That's not going to work out. So the focus again is on establishing power of control over the employee, which they failed to do so here. Finally, as an additional reason, and this had its own part, and as I said earlier, they didn't describe how the beneficiary was going to be in a managerial responsibility or duty in the U.S. And this is pretty much like 80% of the time when cases are denied in these kind of L1 EB1C contexts is because they do a horrible job proving that or showing that by preponderance of the evidence that they're going to be employed in a qualifying position. But the interesting thing that was happening here, which is happening a lot now that the systems between internal USCIS and State Department are so matched up, is they looked at another EB3 perm filing for this beneficiary and saw the job duties that were listed. And they compared it to job duties now, and they said the EB3 context, that was going to be a regular employee. EB1C, that's going to be a manager or executive. Those don't match. They say, no, they're different things, but USCIS says, no, this is the same situation. You're trying to get at it in two different ways. We're using that against you, that discrepancy. So you got to be careful. You got to ask clients about that. Again, I might have mentioned this in previous podcasts, but they are checking State Department records. And people do get caught saying in a DS-160 on their tourist visa or on a student visa that, no, I wasn't employed, and then coming back doing L1 and saying, oh yeah, I was employed 1 year. They're going to check that now. The technology has made it easier for them to do it. And if the officer has the patience to look back or has suspicion where they need to look back, it's very simple for them to do. So you have to ask the clients, if possible, get a copy of their DS-160, which they usually don't keep. FOIA it if you can. I haven't FOIA'd it before because I haven't had to. But State Department FOIA is a little weird. Sometimes they don't give you anything. But it's worth a shot to be careful because it could create a lot of problems. The next case is a cool case. It does a great job breaking down the functional manager L1A or in the context EB1C responsibilities or adjudication guidelines. Now, the functional manager is something I avoid using as much as possible because the standard is so vague that I don't like leaving it up to chance of doing that. But if you need to, you can do it. Now, in this case, I wouldn't have done it this way because in this case, the company had 250 employees and it had over $100 million in earnings on the petitioner's most recent tax return. So when you have that kind of employees, you could show the company somehow that they were executive, they had people underneath them, managers, all that kind of stuff. So to go out of your way to do a functional manager case that leads you open to initial denial, which would require an AAO appeal, didn't make sense to me. But they sustained it. Now, they cite matter of Z in there too. Go see this case. It's called Matter of G, Inc., February 17, 2017. I'll have the links to all this stuff in the show notes. But I'm not going to go into too detail, but it really breaks down what they consider the rule for a functional manager. It's kind of like a law school exam, the IRAC is. So like they have a rule and then the analysis based on the facts. And the rule, so they have like a 5-parter here breaking down the different parts of the functional manager. And it's going to be very helpful to give you an idea of how to look at it. But again, these functional manager cases that are approved on AO appeal, they're usually these humongous companies that could have probably worked out somewhere or another if they just put it in as an executive and did the description of job duty right, made a job chart showing all that kind of stuff, what responsibilities are and who the employees are, all that kind of stuff. I don't like messing around with functional manager. It's like playing with fire. That's the last option for me. Just a manager context in general I avoid. So that's that. Now, going to the fourth case, this is another one of those fancy lawyering mess-ups. Disappointing lawyering, if you will. In this case, it's a matter of USAM-W-A-D-M. There's another case, matter of M-A-B-W. Surprisingly, I think they're totally different cases, facts and everything, but they both came during the same time period about the joint venture aspect for qualifying relationship. I'm going to kind of merge these two when I'm talking about it. So if you look into one of these, you might not see both of them, but I'm just saying most at once. And it wasn't well thought out. This could have been fixed, in my opinion, if they just did it right, or maybe the business or the reality of it wouldn't allow it. But the interesting thing is, in that first case, and I usually cite to the matter of USAM-W-A-M-blah, blah, blah, February 20th, 17th, it says the director certified the decision to the AEO because the case involved an unusually complex or novel issue of law, which I didn't really think it did, but sure, if they say that. Now the issue is the term joint venture has never had a proper definition in the regulation. But they say precedent case law states that a term joint venture applies to a business enterprise in which two or more economic entities from different countries participate on a permanent basis. This is citing Matter of Hughes from 1982, which is an important case to read and know and have in your L1 EB1C handbook. And then they say further, both under the Uniform Partnership Act and the Florida Revised Uniform Partnership Act, it requires that the partnership which a petitioner and the beneficiary's foreign employer claim to have formed through the purported execution of a joint venture agreement, it must be an entity that exists separate from the partners that comprise the partnership. So essentially in these cases, what they did is there was a U.S. petitioner that was completely its own company. There was a foreign company that employed the beneficiary for 1 year or more. And these two companies came together and said, we have a project we want to set up. We're going to set up this separate joint venture that's going to do it 50-50. And the employee is going to transfer, and this is where it gets funny, but employee essentially is transferring to the U.S. joint venture to operate the joint venture. Now, this is where the problems erupt. In these cases, they put the U.S. company that was not the joint venture, but the U.S. partner of the company as the petitioner. However, the employee, the beneficiary, would actually be working for the joint venture. And the foreign company had no relationship with the U.S. company petitioner. So there was no qualifying relationship. If they both have 50% ownership in another joint venture, it's kind of like their subsidiary, each owning 50-50, the petitioner here or the U.S. company doesn't have a qualifying relationship. The foreign company should have owned the petitioner ownership and control, maybe own 1% of it but control the company, or vice versa. Or the petitioner should have been the joint venture itself. That way we could say the foreign company owns 50% of this U.S. company, and that U.S. company is a petitioner. Now here, first of all, the U.S. company, the joint ventures were new, so they wouldn't qualify under the 1-year statute for the EB1C, which means the existence has to be open for 1 year and operating. And two, in these cases, they never registered the joint venture as a separate legal entity. Never had an ITIN number, federal ID number, federal ID number, and all the rest. So they both of them are confused. The director says, I'm confused. Why is the petitioner petitioning when it should have been a joint venture? But nonetheless, if the joint venture did, it wouldn't work either because it was not properly registered, wasn't in existence for the necessary amount of time. It didn't make sense. And this is something that should have been easily caught. I'm not sure why this is a difficult situation to grasp, but they have to ask the AEO as a complex issue. So the case failed, obviously, in both cases, and they lost out of a lot of time wasted. You know, time is so important. When businesses come to me, like I'm dealing with another case that another alleged attorney filed the L1 and they're waiting on a decision, they do pre-processing. And I'm telling them, listen, you guys are successful. Every day that goes by where you're waiting on an L1 decision, that's a bunch of money that could be made. In my time right now, you know, my office, and I'm a solo, but I'm doing so many things. You know, I get Uber Eats as much as I can, and their service is starting to suck so bad, I'm going to stop. But I'm paying like additional amount of money to have it delivered to me every day. But for me to walk over to the store next door and wait in line for the food, it's worth the $5-10 extra I'm spending, because on the other end, sitting in my office and thinking about cases or marketing or getting a case and getting it done, it's going to make me way more money. Now, I enjoy sometimes walking the store and just being around people and stuff, and I do that as necessary. But to waste time for a multinational business that could potentially make $1 million is a ridiculous thing. So waiting on an I-140 decision, which doesn't have pre-processing, takes forever, and then appealing it to the AEO doesn't make any sense. They should have just done an L1 with the joint venture, transfer the guy over or the gal over first, waited a year, see how well it developed, then did the EB1C. You know, the person would be here, they'll get their green card a little later, so what? If it was that big a deal for the companies, they could have transferred to the petitioner and developed some sort of ownership control. Which actually goes back thinking about one case I was going to talk about earlier, which is an issue I have. Now, when I talk about terrible lawyering that happened in these kind of cases, it's not necessarily always the lawyer that does this. I have a case that matches, I think, the second case I talk about, where there's a foreign employer. The employee wants to come to the U.S., do an L1, eventually get the green card. Now, the employee never wanted to be directly working for the company because the tax treatment he would have received would have been better if he was considered like an independent contractor. So I don't want to give too much details of the case, but the foreign companies in Western Europe, which would essentially be the parent company, but that's a nuance too I'll talk about. The other employee is a non-Western European country, and he found that if they just pay him and they wire the money into this other country's account as a independent contractor, it's going to alleviate a lot of taxes for him. But he has a work permit in that Western European country, always working there. And so I think I could put together that he is an employee, even though it's kind of like that Irish case. But when they transfer money for his wages from the Western European company to his bank account, it goes to his business bank account, which only has one type of deposit every month going in, which is his payment. And the company is wholly owned by him, 100%. So it's really obvious connecting the dots that this is a company used just for the wages to go in. The guy has a work permit for that country. He has a business card that shows there. He has contracts he signed. He has an employment agreement that specifies this. They pay for his phone bill and his lease in that home country. So there's all these different documentation I'm showing that this guy's really employed. I was worried at first about this. I had to study a lot. I was comfortable enough with filing that. But then the next step with this case, and then it goes to these qualifying relationship kind of stuff, is the foreign Western European company is afraid of the U.S. tax system, so they want to make a subsidiary, and they're gonna control it really, but they don't have ownership. And when you go to these qualifying relationships in 8 CFR 214L, what is it? I'm trying to memorize all these CFR sections. But in the section for L visas, it says that, there's different ways you could do a subsidiary relationship. And the last line of it, it says, it's about ownership and control. You could have a minority ownership, but just have control over it. So I said, listen, ideally they would own 51%, make life easy on me and you, but the foreign company doesn't want to be majority owner. So I said, okay, maybe 10, 20%. At the end, I'm just like, let's try 1%. Foreign company owns 1%, but the rest of the board, or the owners, actually the shareholders, up to 51%. We put it together that they write letters saying we give full control of our voting shares, 51%, or maybe even 50% to show they have the negative factor they could deny everyone else, is to that parent company. And I was like, well, I'll give that a try. I think I could argue it technically is right in the books. I know they could give you problems on that, but we're right. If you really want to do it and they really want to do it, I said, okay, we'll do it. Come back later, they say, actually, the foreign company is afraid. They don't want to deal with U.S. regulation, this and that, so they don't want the 1%, but we still want to go ahead. I said, listen, brother, that doesn't make any sense. If we have only control and no ownership, that's going to be a problem. They're going to deny the case. And he comes like, no, I don't care. I want to do it anyway. So then I went back to him, listen, do you really want to spend tens of thousands of dollars on business lawyers, my fees, filing fees, waiting the time, investing in the business, do all that kind of stuff just to get a denial? And let's say the L1 is approved, because L1 is sometimes just non-immigrant visas. You get away with stuff. I like O1 cases that are ridiculous, I see. But let's say the L1, you get it. They're going to catch this on the EB1C stage. The officers pay attention. And so don't mess around. And I lose a lot of money just being real with my clients, but I'd rather do that than get a bad review on Yelp saying this guy, messed with me and wasted my money. But barring that, in addition to that, I just don't want to waste the guy's time and money. It's not necessary. So that was my 2 cents on these recent cases. Sorry if I was a little harsh on the lawyers, but if you want to see examples of bad lawyering, read these AEO cases. It's incredible that these people have the courage to take money from clients and appeal these kind of cases, which are so obviously bad. Now, there's nuggets of sustained appeals, which are good, but especially in the L1, EB1C context, majority of them are awful. There is no point in filing, I would say, at least 51% of these cases, let alone appealing them. So unless the employer or the petitioner just said, screw it, let's do it, even then they shouldn't do it. Their name's on this case that they would file something so bad. Now nowadays they don't say who the lawyer was and stuff in these cases, but it's on the ethics side, I think it's a big problem I'm seeing a lot on these cases that people are even imagining or having that are even doing this. But it's really good for helping learn the limits of these cases. So it's really important to read. It's very difficult to read because there's so many of them, especially L1s. It's very time consuming to go through them. I read them all, and I do for EB1C and L1s. I do synopsis of them. it's too much work to post them all up. I do the L1s on my website, jqklaw.com. Under the L1 tab, there's synopsis of these cases if you want to just read them. They're a little shorter than what they have. Instead of 16 pages, it'll be like 2 pages on my site for each case as they come out. But for EB1C, I have them, but uploading them on my site takes so long that I have like a year or two's worth of EB1C cases I haven't posted. But hey, if you had the time, go back 5, 6, 7 years. They're there on these L1 cases. Once you read, I don't know, 1,000 L1 cases on AO Appeal, it turned into Nemo from the Matrix, where you could just see an L1 case from a mile away, know where the glitches are. It's pretty fun, and it makes you very comfortable. So when the clients do come to you and they ask you, you give them a lot of confidence, knowing that you're just so comfortable with it. You've seen where the borders of these are. And sometimes borders aren't clear, but you know where you could push and where you can't. And that's a very good thing on these kind of cases. That's kind of lawyering I would expect of my lawyer to do. That's why I primarily don't take on certain types of business cases, because unless I'm going to put like all my time into studying it day and night, kind of like a martial arts practitioner, putting their discipline into what they're doing. If they're learning whatever branch of the martial arts they're doing, just putting their all into it. But it's really good to read these in a case here or there, to get yourself on top of it. They're lucrative cases, so it's worth the time, definitely. And the clients are excellent usually. I really enjoy my business clients because they're just on top of it. Their documentation is good. I learned so much from them, various aspects of life and business, and they've seen the world. It's just a really good friendship that develops, and it's a gift that keeps on giving. L1 is you have to renew it, EB1C eventually citizenship. So it's a good long-term client that has money. So on that aspect, its business is good. On a personal level, it's good too. That's why I love business-based immigration cases. I hope you enjoyed this episode. Please like us on YouTube and follow. If you're on iTunes, please leave a review and follow. If you're an attorney, feel free to contact me, info@jqklaw.com, to become a member of the Immigration Lawyers Listserv. You can go to immigrationlawyerslistserv.com, and the way listserv is spelled is going to be weird, but just go to jqklaw.com. In the top left, there'll be a button for the listserv, and you could learn what that's about and do that. And if you have questions, comments, corrections, anything, just email me, info@jqklaw.com. I'm always interested in learning more, so I'm down to hear it and develop a relationship. And feel free to listen to my other podcasts, and I'll have a weekly recap coming up this weekend, which should be fun. Thanks so much. Y'all have a great day. Bye-bye.